The following is an exercise of the First Amendment rights of one individual. Next year, McLennan County Judge Jim Lewis will be up for re-election. What you need to know. In 2006, Jim Lewis cast a deciding vote to remove a constable the people elected. This is despite the fact McLennan County District Attorney wrote an opinion that the constable had done nothing wrong. In the same opinion, the District Attorney wrote the Commissioner's Court had no obligation to remove the constable elected by the people. They could, in fact, have done nothing and allowed him to serve out his term that he was elected to by the people. So why did County Judge Jim Lewis, Commissioners Meadows and Crunk vote to remove a constable elected by the people, who the DA and AG said did nothing wrong? It is simple. Jim Lewis did not like the person chosen by the people, so he just threw the Texas Constitution and election laws under the bus. The reality is, Lewis was unhappy with the Constable Brown, and in retaliation eliminated his precinct. This is consistent with how dictators have operated for centuries. If it was one guy, it might fall into the category of elections have consequences. The difference is shaft because they were denied the elected official they voted for, and in true dictator form, Lewis chose their elected representative. In 2006, there was an election and the same people who were denied their elected constable went to the polls and elected a new justice of the peace. This happened because Lewis was not able to accomplish redistricting in time to get the names removed from the ballot. Lewis says the precinct was eliminated prior to the election, so the position does not exist. Do you think there might be a law which prevents voters from being denied the elected representative they elected, or prevent the government from arbitrarily preventing people from voting for their elected officials? This 1983 Secretary of State opinion indicates changes cannot be effective for an election until the following voting year. In the 2006 election, the following voting year would have been March 1st, 2007, after the person they elected took office on January 1st. At least in 1983, the Secretary of State thought voting rights were important. Next, look at the Texas Constitution. Article 5 establishes the authority of the court to redistrict. Section 18 was amended by the voters to address the exact situation at issue. Elected to a term of office beginning on or after the effective date of the change. Seems pretty easy to understand. Around 1983, a court decided it was okay under the Constitution to disenfranchise voters. That was the Ashmore decision. In response, the voters amended the Constitution to prevent the exact action Jim Lewis engaged in. Look at how the district attorney applied the amendment. The individual cannot, by his or her decisions, extinguish the right of the state and its people to have the benefits provided by an official. Texas could have just as easily rejected the 1983 amendment to that article and left Ashmore the law of the land. But they didn't, and it isn't. The district attorney makes a very articulate case that the people are entitled to the official that they elect. The people reaffirm that right through a constitutional amendment. The amendment exists to avoid the disenfranchisement of voters. Hello? When the people go to the polls and vote, it should mean something. In a representative republic, it does mean something. In a dictatorship, it doesn't mean anything. Jim Lewis not only ignored the voters in the JP election, but totally disregarded the Texas Constitution, a document he swore to in his oath to uphold. Some think the issue was resolved by the courts. Not exactly. The 10th Court of Appeals was asked to order Jim Lewis to issue a certificate of election to the person that was elected by the voters. No one has answered the question on the constitutional rights of the voters. It might have been addressed by the Attorney General in response to the previously referenced request, but the district attorney specifically included the question in the request. The letter does not ask you to address an individual who is elected to a term of office beginning on or after the effective date of the change. Why has the issue of elected to a term of office not been addressed by the Attorney General when the amendment went into place 26 years ago? The answer is simple. No other county judge has been so arrogant. They redistrict in odd number years when it has no effect on an election. Only a dictator who is politically motivated would engage in activities to violate the constitutional rights of voters. County Judge Jim Lewis removed a constable who was elected by the people and who the district attorney said did nothing wrong. He disenfranchised voters by denying them the elected official and gave them an elected official they were prevented from voting for. Other points of interest. Half the voters in the 2006 election were put in a constable precinct where the constable did not even live in the precinct. That constable was originally appointed by Commissioner Ray Meadows. In the 2006 JP election, the incumbent was a Democrat who served for 10 years and never faced an opponent. The incumbent was defeated by a Republican challenger by 4 votes. The seat had never been held by a Republican. The same incumbent who was defeated was shortly thereafter appointed as jail magistrate. The people, by popular vote, removed him from office, but Jim Lewis made a job for him. The good old boy system at its best. In 2008, the magistrate of the combined precinct retired. Even though the person elected by the people in 2006 lived in the combined precinct, Ray Meadows and Judge Lewis voted to appoint someone else. This made the 3rd time those voters did not get a say on their elected official. Someone is going to say that this is mudslinging and that someone that acts to grind with Jim Lewis. It's really stupid to think the Secretary of State from 1983, the Texas Attorney General, and the McLennan County District Attorney all have to act and engaged in a 2-decade conspiracy to defame Jim Lewis. I don't know if Jim Lewis thought the people were not paying attention or if he just thought the voters were too stupid to figure it out. Please review the Secretary of State opinion, District Attorney opinion request, and the Texas Constitution and decide for yourself. The question is simple. Are voters entitled to the person they choose to be their elected official? It appears Judge Lewis and Commissioner Meadows believe they are far better qualified than the voters to make that decision. Stop the dictatorship in McLennan